Had no time, had no date, and the state was unable to present any evidence with any reasonable degree of certainty as to when those Google searches were made, allowing the jury to guess and speculate as to when those actual searches were made. Now, the state argued that because these searches came off of Tim's work laptop, that it must have been done by Tim. But that does not take into account, it does not exclude, or it does not allow for the fact that Tim had 3 boys in his home on at least a 50% of the time basis that would have had access to this. But that's beside the point when you can't even establish when the searches were made to begin with. But I do want to intimate the fact that there was no direct evidence suggesting that Tim made the searches on his own. In addition, there was no evidence to establish that these searches were done all at the same time, all at once, or whether they were done separately over the course of time. The evidence is essentially unrebutted that they were unable to show when these searches were made, who made them, and when they were done. We don't know what searches were made before these. We don't know which ones were done after these. We have absolutely no context that the state provided other than the searches that were made. And I argued during my closing argument, and I'm arguing here today, that when those searches were done is exceptionally important to the evidentiary value that those searches hold. If those searches were done any time before Becky's murder, I would have to agree that they have probative value and they should come in. If they were done after Becky's murder, I'm not certain what the probative value would have been as far as Becky's murder is concerned. The night that Becky was murdered, the police had access to Tim. They had access to Tim's father. Tim's father was attempted to be questioned by the police. Tim and Becky's co-workers were questioned by the police. Friends were questioned by the police. So it was no secret as to what happened to Becky. And if these searches were done after Becky's murder, it is just as plausible to infer that it was Tim or one of his sons looking up or seeing if the information that they could have possibly come into was true or false, given the fact that shortly after the murder, the rumor mills tend to churn. But certainly there was information out there that was true. There was certainly information out there that was false. And it is only human nature to look into the death of your spouse and the nature and manner that has been intimated that these searches occurred. But in any event, with respect to those Google searches, we suggest and argue that it was improper for them to be admitted due to the lack of foundation. Along with that would be an error that the state made when Mr. Jones argued in his closing argument that the court file and all of the evidence had been sealed and Tim would not have known any of the things that were presented to the court at that time. And again, there was no evidence presented to the jury that this file was sealed or that Tim otherwise had no access to the details of Becky's murder after her murder but before his arrest. Mr. Jones took it upon himself to announce to the jury at that point in the trial where I had no opportunity to rebut. If I were to have objected to that statement, then I draw attention to it. I made a judgment call and I let it go, and I hoped that the jury would follow your instructions to ignore anything or any argument that was not based upon the evidence. But that comment certainly was not based upon the evidence. And once that bell has been rung, you can't unring it. And with respect to sealing the file, that was done. Next, I want to make mention to what I will refer to as the Drew Peterson doctrine. We had a very lengthy pre-trial hearing regarding whether or not Your Honor would allow in certain hearsay statements. Over my objection, my continued objection, the court allowed in those certain hearsay statements per the Drew Peterson case. It is essentially impossible to cross-examine these statements, and definitely impossible to effectively cross-examine them when the person that you are dealing with did not make those statements. And the problem that they have with these statements is that in Peterson, the hearsay statements that we're to allow in, we're dealing with other criminal conduct. So we intimate that the court overreached and overstepped its bounds and expanded the Drew Peterson case to a realm that it was not intended to be expanded into. So now we're in the position where we can use hearsay statements that were attributable to a civil case as opposed to a criminal case. And the concern that we have in that regard is that if the Drew Peterson case has now been expanded to a divorce case, is the next step going to be a petty traffic offense or something, a DUI or small claims? And so it is, and not to mention the fact that not only were these hearsay statements allowed in, but they were allowed in, to my count, 8 times, time and time again, over and over and over again. I made my rulings during the pretrial motion. I made my continuing objections during the course of trial. But nonetheless, all of those statements were allowed in, despite the fact that they are traditional hearsay statements that cannot be effectively cross-examined on and should not be allowed in due to the fact that we were not dealing with other criminal conduct, but simply a civil matter in a divorce. And if we're going to do that, I think we need to, ask ourselves how far down this path we are going to allow ourselves to go in allowing hearsay statements in. Based upon the Google searches that came in without an appropriate foundation, that allowed the jury to guess. And the jury was specifically told that they could not guess and they could not speculate. Allowing those searches in allowed the jury to guess and speculate as to when those searches were done, which nobody, especially the state, could prove with any reasonable degree of certainty. Coupling that with the court's interpretation of the Drew Peterson case and allowing these hearsay statements to come in time and time and time again without being able to cross-examine the declarant was a violation of Tim's due process, of his constitutional rights and his right to a fair trial. And we would specifically and respectfully request that the motion filed herein be granted and that the verdict of not guilty be entered, or in the alternative that a new trial be granted.
Thank you, Ms. Schnock. And then Mr. Jones or Ms. Keck?
Thank you, Your Honor. I'll address the issues that Ms. Schnock raised first, and if the court wants me to address any of the other issues in the post-trial motion, I can, but I'm just going to focus on the ones that Ms. Schnock argued.
That would be fine.
With regard to the Google searches, Your Honor, and the lack of foundation, I think we have to start with the principle that foundation is just about whether or not it's admissible to give to the jury. Counsel's argument today goes to what weight the jury should have given to it. That's the argument we made at trial, that the foundation was appropriate because it was a laptop found in the defendant's possession that was in fact the defendant's laptop, and the searches were found on that laptop. That's the appropriate foundation. That's all we have to do for foundation. There is no case law. There is no ruling of a court where a Google search for a foundation has to have a date or timestamp on it. Counsel was free to argue, and in fact did argue, that because there was no date or timestamp, the jury should not give it much weight. We were free to argue that the jury should give it weight based on other facts, and that's the nature of the argument. It's not a question of foundation at that point. It's a question of weight as opposed to admissibility. And again, it was subject to cross-examination. The defense had every opportunity to cross-examine those witnesses who testified on that, and they did cross-examine those witnesses as to the lack of date and time stamps on that. I would also point out to the court that the full extraction from that laptop was provided to the defense, and they had every opportunity to examine it themselves. The second point that she raised on that was a comment that I made in closing arguments with regard to the seizure of the laptop. I think it's important to point out that that wasn't made in my first closing argument. That was made in rebuttal, and that was made in response to the suggestion that was raised by the defense that there was that the defendant could have been investigating his own case. He could have been investigating the murder of his spouse. I would point out that there was no evidence of that, and much like Ms. Schnock had the opportunity to object, I could have objected. I chose not to object because I was allowed to respond in rebuttal that there's no evidence that he was doing this, and that in fact certain items had not been made public, and that he was searching for things that were not generally known to the public. That was an invited comment based on the suggestion by the defense that the Google searches should be ignored because the defendant was, again, without any evidence that the defendant was doing this, that the defendant was searching or trying to investigate his wife's own murder, or that apparently one of the three boys was doing that. With regard to the second argument that was raised, the Drew Peterson case, I do want to point out, I think it's important to note that the testimony that was used in the Drew Peterson case to get to the murder was in fact a divorce case, just like we have here. We're not using any different evidence than what was used in the Drew Peterson case. In the Drew Peterson case, he was going through a divorce, or the divorce wasn't final yet, just like in this case. The victim in the Drew Peterson case was going to provide testimony, provide evidence in that divorce case, just like in this case that we had, and she had made statements to other people that she was scared or fearful of what was going to happen to her based on her relationship with Mr. Peterson, just like Becky made statements in this case. It's a point-for-point comparison. Really, it's so often when we're trying to argue case law, we're trying to go up or down the ladder of abstraction to make the cases similar or less similar, depending on which side of the table we're standing on. But, Your Honor, this is one of those cases where it's eerily similar. It is nearly a point-for-point exact match for the case that we had here. And finally, in regard to that Drew Peterson case, the court here was required to make specific rulings before we could even use that hearsay evidence. It's not like it was just presented to the jury. We had to show the court the basis for that, and not just the basis for the hearsay, but the court had to make a finding by a preponderance of the evidence that the defendant committed the crime first. So we're not just willy-nilly letting hearsay statements in. There were several steps. There were several layers of protection for the defendant's rights before we even got to that point. And we followed the law. The court followed the law. The court followed the rulings of the Illinois Supreme Court and what we are allowed to do under specific limited circumstances. And we did exactly that. So again, based on case law, all the claims of due process were covered. His due process rights were protected. They may not like the result, and I understand that, but the law allows it to occur in this specific instance. And the court followed that, and that's what we asked the court to do. I think that's the two issues that Ms. Schnock raised. I'll address those. If the court wants me to address anything else, I will. But that's our argument.
All right, thank you, Mr. Jones. Ms. Schnock, you wish to be heard further?
Yeah, swinging back around to the Google searches, Your Honor, the state couldn't establish who and the state couldn't establish when. And when you can't establish who did it and you can't establish when they did it, then you're allowing the jury to guess when, and you're allowing the jury to guess who, and they were specifically instructed that they couldn't do that. And when you can't tell us who did something or when it was done, it should not have been admitted to begin with. Secondly, with respect to the Drew Peterson case, there is a distinct difference between this case and Mr. Peterson's case, and that in this case, on at least 8 different occasions, 8 different people came in here and said essentially the same thing, which was a complete disregard of my objection based upon the evidence being cumulative at that point. It was certainly more witnesses than was necessary to make the point. I understand that the state has their prerogative in how to present their case and how many witnesses to call and what to call them for, but and that is a distinct difference here if you want to compare it apples to apples to Drew Peterson's case, is that in Mr. Peterson's case it was one person. In this case it was 8 different people that could not be cross-examined basically regarding the same statements.
Thank you, Ms. Schnock. The court has considered the arguments of counsel, has considered the written motion. The court will address some of these specific issues in the motion, basically which were argued by counsel. First of all, we'll take the Google searches because that's also the basis of another objection as to the comments to the jury. As to the Google searches, there's 2 different factors that you must look at with that. First of all, whether or not the searches themselves are admissible, and the people have to lay a foundation in order to do that, to admit them into evidence. The people did that by providing that the laptop was the defendant's laptop, was in the custody of the defendant's laptop. I believe it was also password protected, which adds another layer of protection on there. So the people actually laid a foundation for the admission of those. The rest of that, since there is no date or timestamp, goes to the weight of that evidence. Not whether or not it's admissible, but what weight should be given to that evidence. Both counsel argued as to what weight should be given to that evidence, and it's the jury that gets to decide what weight to give to any particular piece of evidence, and the court cannot at this point assume or determine exactly what weight was given to that, but whatever weight was given to it, that's the jury's prerogative, and it was not error to allow or to admit that evidence because the people laid that foundation, and then the jury did what the jury decided to do with it as far as what weight to give it. We don't really know because there isn't anything to show whether or not the jury considered that evidence or totally disregarded that evidence. So there is no error there. And then we're going to go back because part of the defendant's argument is comments made about that information that was in the Google search. It was made in argument to the jury. The jury is instructed that they are to disregard any argument that is not based on the evidence at trial. That's one of the jury instructions. The court gave that instruction. The court assumes that the jury followed that instruction. So there is no error in that argument. It should also be pointed out that that argument was made in the rebuttal, which was an answer to the argument made by the defense counsel, and those are looked at much less strenuous than the original argument. So the court finds no error in that argument, certainly none that would rise to the stature of granting a new trial or finding the defendant not guilty. Also, there was other parts of the argument that is in the written motion but not argued here that is basically of the same category, that there are comments made by prosecution that wasn't necessarily part of the evidence presented at trial. Again, the same ruling. The jury is instructed to disregard those arguments if they're not based on the evidence. Court believes the jury did that. There's nothing to show that the jury did not do that. Then we come to the hearsay evidence, which comes from the Illinois Supreme Court case of People versus Drew Peterson. That is almost exactly the same facts that we had here, where the defendant was accused or charged of murdering his wife. They were getting ready to go through a divorce, and the Illinois Supreme Court determined that pursuant to the, in that case, that pursuant to the waiver by forfeiture, that the defense could not keep out hearsay statements, because one of the ways those statements would have come in would have been if the alleged victim were to testify. Well, because of the actions of the defendant in both cases here, where the defendant was alleged to have killed his spouse, she was unable to testify, so the doctrine of forfeiture is applied. And again, this case was almost directly on point. In fact, I think it was as close as any case that we've ever used is on point with allowing evidence in. And so the court followed that case. In fact, the court did keep out some statements that were made that the people wanted to use, that the court found should not be allowed in. And that was at one of the pretrial hearings where the court did not allow the media in because we were having hearings on sensitive matters that could affect the trial. But anyway, forfeiture by wrongdoing applied to the hearsay statements in this case as set out by the Illinois Supreme Court in People versus Drew Peterson. And so the court followed that case law, and the court does not believe that it was error to allow those statements. As to any other claims made by the defendant, the court does not believe that those are well-founded, and so the court has considered that motion, and the court would deny the motion. And then we will proceed to sentencing. And Mr. Jones, are the people ready for sentencing hearing?
We are, Your Honor.
And Ms. Schnock, is the defendant ready for sentencing hearing?
Yes, Your Honor.
The court has received a pre-sentence investigation report as well as a first addendum to the pre-sentence investigation report and a second addendum to the pre-sentence investigation report. Mr. Jones, have you received have you received those reports? Have you had a chance to review those reports, and do you have any additions, corrections, or deletions?
Thank you, Your Honor. We have received that report. Ms. Keck and I have had an opportunity to review it. We have no additions, corrections, or deletions to report to the court today. We would have no evidence in aggravation to present to the court today. There are victim impact statements that we would ask the court to hear.
All right, and Ms. Schnock, have you received those reports? Have you had a chance to review those with your client? And do you have any additions, corrections, or deletions?
Your Honor, I received the pre-sentence investigation reports in a timely manner. I have had ample opportunity to review those, as has Mr. Bliefnick. I have no additions, corrections, or deletions to offer the court. I have no evidence to offer the court today, merely argument and mitigation.
All right, neither party has evidence. Then, Mr. Jones, you have victim impact statements that you would like to present?
We do, Your Honor. If we could start with Bernadette Postal.
Okay, and how are you going to want to do those?
Ms. Postal will be sitting at the table with us.
Okay.
And then the remainder of them, I believe, will all be from the witness stand. They won't be sworn, but they'll be
All right.
reading from the witness stand.
That's fine, yes. Just make sure we have the microphone by her. Ma'am, you may, but if you're going to read something, though,
I'll have her.
I want to tell you, please read slowly, okay? So a lot of us, when we start reading something that we've written, we go real fast because we know what it says, but nobody else knows what it says. And so if you would try and go slow, I'd appreciate it, okay? Go ahead, ma'am.
I'm Bernadette Postal, the mother of Becky Bliefnick. When you murdered Becky, you took from your boys the person who loved them the most on this earth. You replace their mother's love with emotional scars and trauma that will last their lifetimes. Becky's family, friends, co-workers, and patients will never again see her smile, hear her laugh, feel her embrace, or receive her love. We are left with emptiness that cannot be filled. We are only left with memories. Your soul is black with hate. Your heart has only love for itself. You should never be allowed to be free again.
Thank you, ma'am.
Judge, the next victim impact statement is from Suzanne Parker. It will be read by Tricia Hubbard from our office, our victim advocate.
Just make sure you pull the microphone down. Thank you.
My name is Suzanne Parker, residence Durango, Colorado. I am one of Becky Bliefnick's 3 aunts. The news of Becky's death came to me on the day she was murdered, February 23rd, 2023, when my brother William Postal telephoned me to say he had found her bullet-riddled dead body on her bathroom floor. My life since that day has never been the same, and I fully expect that to be the case for the rest of my life. Since that day, I have had no more than a few full nights of sleep, often instead lying awake, mourning all that was taken away from Becky and all the suffering her murderer's cruel and unconscionable actions have taken from all of us who knew and loved Becky, most particularly her 3 little boys, her parents, and her only sister. I can find no explanations in a normal world for such monstrous behavior except that these actions were those of a despicable, conniving, totally self-centered, and greedy narcissist. This convicted murderer deserves few words spent to describe him. Becky, however, deserves to be remembered forever for her boundless love, kindness, and caring for others. In my physical and emotional pain and that of Becky's other family members, friends, and caring colleagues and community members touched by her. We can only keep her in our loving memories. She lives on in her 3 sons, and we must content ourselves with that and with how she enriched our lives. I personally have had to seek medical assistance for my insomnia and digestive issues created by this tragedy. But those will be worth it to me to know that you, Judge Adrian, give Becky and all who love and miss her justice. I implore you to bring that to our murdered loved one and take away forever all chance of freedom from the monster who murdered her. Thank you, Suzanne Parker.
Thank you.
Judge Terry Schultz.
Ma'am, if you'll come up around here, have a seat in the chair. Then make sure you scoot up to the table to where you're comfortable and bend the microphone so it's in front of you, all right?
Okay.
You may proceed.
Tim, I was at your wedding rehearsal when you and your family proclaimed to all those present how much Becky was loved and welcomed, that it was a blessing to have such a wonderful and kind person as the newest member of the Bliefnick family. She couldn't have been placed on a higher pedestal that night. Everyone who was there would remember. I was there the next day at St. Francis Church when you held Becky's hand and looked into her eyes and proclaimed before God your love for her and your dedication to her. Remember, love and honor, better or worse, cherish. To accept children lovingly from God and bring them up in the faith of Jesus Christ. But that was not the only time you made empty promises before God and before Becky and before all the other witnesses of family and friends. Once again, standing before God during the baptism of each new son, not only did you vow to reject Satan and all his works and all his empty promises, you promised to follow the covenant that was made for you at your baptism, to proclaim the works of God in word and deed, to serve following the example of Jesus Christ, to live that example for Deacon and Grayson and Arlen. Divorce happens, marriages end, Love of a spouse wanes. But the bond you created as a parent never ends. The commitment you made as a parent demands that you continue to cherish and respect your vow to your children, showing that example of love and forgiveness to your children. On February 23rd, your actions spoke to your true self, to the lie that you had been living. On that day, you proved that you didn't reject Satan, but embraced him. You once again looked into Becky's eyes, but instead of holding her hand, you shot 14 bullets into her body, and you left her dying on the floor like a wounded animal. The mother of your sons. The woman who you no longer loved as a spouse, but who you, in your divorce proceedings, you agreed to respect as your co-parent, so your boys could grow up learning the lessons of compromise, open-mindedness, and forgiveness, so they could witness courage during difficult times. Instead, they now see a coward for a father, an example of raw evil. You can never again profess love for your sons, having taken so calculatingly and callously the mom they so desperately need to provide the gentle touch that says, everything will be okay. Or the mom whose loving embrace says, you are my son, and I love you with all my heart. Or the mom who would laugh with them at their silly jokes and should be there to support them in all their moments of childhood and adolescence. The mom who should be there at their side when they're sick and who cries with them when they're hurting. But you made sure that they will never again experience any of those moments with their mom. Becky's days of living in fear have ended. She's the one person now at peace. But for each day that Deacon, Grayson, and Arlen will wake up missing their mom, for each day that Bernie, Bill, Sarah, and countless family members and friends who will feel the loss of someone they loved and longed to have back in their life, for each of those days, may you spend in a prison cell alone. But even then, your punishment will not be nearly as agonizing and painful as the death sentence you forced upon Becky. And for what?
Thank you, ma'am.
Next statement, Your Honor, will be read by Chris Schultz on behalf of Lauren Schultz.
Again, if you'll scoot up to the table and where you're comfortable and bend the microphone so it's in front of you, please.
Oh, I got out of here. I'm Becky's cousin, Chris. I speak today as the voice of all Becky's cousins, Mike, Jay, Jim, and Lauren. We are burdened by unimaginable grief and an unfillable void. The years of hell that you mercilessly dragged Becky through was no secret. In January 2022, just over a year before her murder, we sent Becky a care package as a show of love and support. Along with the gifts, we included a letter reminding her of our shared roots and the unbreakable bond of our family. Little did we know that our promise to always be there for her would encompass the heart-wrenching task of carrying her casket just 13 months later. We see people commend our family for their strength, but they cannot fathom the depths of our aunt, uncle, and cousin Sarah's resilience. The truth is, our family has no option but to carry on, to navigate the agony that's been thrust upon them. Every milestone, every celebration, and every family gathering will forever be tainted by the painful absence of Becky. But it's not only the big moments that remind us of the void. Grief seeps into every crevice of our lives, even the smallest daily interactions, like when her name and photo still appear in our family group text. The ache of knowing she should be there lingers, bringing us to tears and casting a shadow over even the most mundane parts of life. Our lives are forever altered, scarred by the knowledge that someone we cherish was taken from us so violently and senselessly. We'll never again hear her infectious laughter, embrace her in the moments of joy, or watch her thrive in the personal and professional roles she was born to fill. A lot has been said in this courtroom about the way Becky died, but to begin to understand the impact of this crime, we must also acknowledge the way Becky lived. Becky was the light, a deeply kind soul that radiated through her voice, unmistakable laugh, and countless good deeds. Simply put, Becky was a good person. Becky provided the most brilliant light for 41 years to her children, her family, her patients, and her friends. The weight of the crime committed against Becky and all those who love her cannot be measured, and no punishment can truly equate to the magnitude of our loss. Tim, any accomplishments you have had have already been erased. You will sit in prison and you will be forgotten. Even to hold hate for you would be a waste. We ask this court to impose on you a punishment fitting of the crime you've committed, to extinguish the light of freedom from your life for as long as you shall live, so that you may never again be allowed to absorb the light of anyone else with the endless darkness of your soul. Thank you.
Thank you.
Brett Riley, Your Honor.
Judge Adrian, everyone in the courtroom, I'm Becky's brother-in-law, Sarah's husband, Brett Riley. There are no words in any language that could accurately reflect the unfathomable impact that your heinous actions have caused Tim. Did you think for even a split second about 5-year-old Arlen as you stood over his beloved mommy, riddling her helpless body with 14 bullets? Arlen, who cried in my arms the last time we were here, begging me not to go back to New York. Arlen, who profoundly misses his mommy and whose life is now forever altered in unfathomable ways. Arlen, whose mommy was 1,000 times more to him than Santa, the Easter Bunny, the Tooth Fairy, and all the Transformers combined. Did you think about 10-year-old Grayson as you charged down his hallway, chasing his defenseless mommy en route to slaughter his entire world? The person that loved him more than anything in the world. Grayson, who wakes up in the middle of the night, crying out for his mommy, who now will never come running to comfort him. Did you think about 12-year-old Deacon as you broke through his window with a crowbar, climbed into his bedroom on your way to murder his mommy, his first love, his loudest cheerleader at all of his ball games, the one person on earth that put the time in for him and his brothers, really put the time in? Will Deacon, Grayson, and Arlen, these 3 innocent victims, ever again trust the staying power of love? Or will they forever fear that their greatest loves could at any moment be taken away forever? Becky was not the only helpless victim on February 23rd. You rode on that bike that night towards all of us. Do you realize that you not only fired your gun at Becky, but you also fired at Deacon, Grayson, Arlen, Bill, Bernie, Sarah, myself, dozens of family members and hundreds of friends, colleagues, patients, and members of the Quincy community who are now forever reeling from the loss of their mother, their daughter, their sister, their cousin, their friend, their devoted nurse. You had zero right to sentence our beloved Becky to death. In doing so, you've sentenced her children, her family, and her friends to a lifetime of profound grief that we will be navigating for the rest of our lives. Honorable Judge Adrian, I plead to you now to take the law into your own rightful hands and sentence Timothy Bliefnick to a life in prison without the possibility of parole.
Finally, Your Honor, Sarah Riley.
My name is Sarah Riley. I'm Becky's only sister. Becky's death was gruesome, painful, and senseless. You wanted her to suffer. You probably wanted all who loved her to suffer. And if that is the case, you succeeded. Losing Becky in any other way, infection, cancer, or a car accident, would have been tragic, heartbreaking, and agonizing. But this, imagining her fear, imagining her begging for her life, begging for her children, imagining her there, lying on the floor of her bathroom, paralyzed, struggling to breathe, and bleeding from 14 bullet wounds, praying to God in her last moments of consciousness to keep Deacon, Grayson, and Arlen safe from you. It's all unbearable. It is an invisible noose strangling our souls, manifesting in my own physical pain and emotional anguish. It is moments of crying so hard I throw up and waking up sweating from nightmares. It is the anger I feel leaving my daughter's room after she wakes up from a panic attack at night, scared because of you, that an intruder will break into our own home. Scared that she is no longer safe. It is the tears streaming down my face every time a memory pops into my head. In every photo I see, Becky is so full of life. Every video of her laugh makes me forget for a moment, makes me foolishly hope for a moment that I will wake up from this reality, a reality that is so impossible to accept. She was my only sister, my best friend. I loved her and continue to still love her with every ounce of my being. She is irreplaceable. I am left here living with and locking away my own suffering so I can move forward with my life for the sake of my family, for the sake of the boys. Because Becky would not want our pain to give you any further satisfaction. But your cruelty goes well beyond just impacting me. You have ripped Becky away from my parents, the same people that welcomed you into our family, the same people you once called Mom and Dad, the same people you called on February 23rd, knowing Becky was already dead, feigning concern that she had not shown up to pick up the boys. You purposely orchestrated Dad discovering her body. Was it to punish him more, or was it just easier for you? Either way, it shows the depth of your cruelty. How many times did you practice your reaction, knowing they would soon call to tell you that she was dead? It is a parent's worst nightmare to suffer the death of their child. But there is no greater torture on earth to know that their child was violently executed by the man that she married, the monster she was trying to escape for 2.5 years. But no matter how much your actions impact us, the most grievous crime to those left living is the impact of Becky's murder on Deacon, Grayson, and Arlen. There is no more selfish act than to rob a child of his mother. And Becky was no ordinary mother. She loved those boys fiercely, and her love was evident in all her actions and sacrifices for them. She was willing to put them first, even during the divorce process, believing that a life with their father as an equal parent was better for the boys than her going with her gut and fighting for majority custody. She was willing to put up with the emotional turmoil that you put her through because she believed you loved the kids. She knew the kids loved you, and she believed that you would put them first, no matter your feelings about her. Tragically, she was wrong. She was wrong in believing that you could love anyone more than yourself. If they haven't already, your boys will realize that their father doesn't love them. They will realize that every time you said those words, you lied. They will understand that you cared more about your own selfish intentions than their well-being, their happiness, and their future. Because a father who loves his children would never murder their mother, no matter how much he hated her. Because a loving father makes sacrifices for his children, knowing that what is best for them is always the priority. Your children's future will be forever impacted by your crime. They are already suffering, crying for their mother that they would wish would walk through the door and take them home to the life they once knew and loved. The raw grief that they now feel will change over time, and we hope that with our guidance and faith, it will transform into acceptance and forgiveness, because that will mean that they have chosen to live with Becky's love radiating in their memory and not with the scars that you have caused. But if those wounds are too deep, their grief may take a different path. It may evolve into their own depression, suicidal behavior, substance abuse, or defiance. The statistically proven outcomes of trauma. Maybe you should have Googled childhood PTSD in between your internet searches for homemade silencers and VIN numbers. Your children will never be able to escape their past. Carrying the Bliefnick name is a sinister stamp on their innocent lives. They will always be known as the kids whose father murdered their mother, and they will be judged. They have already been taunted. Don't you realize how cruel kids can be? Growing up is hard enough without the emotional baggage they now carry and the scrutiny that will forever surround them. Those who don't reject them outright may harbor suspicion. Did they inherit their father's evil? Is your narcissism a family trait, not only passed down through your genes, but through their experiences with you as their father? Did they learn that women should be manipulated, controlled, and abused by the way they saw you torture Becky? when they start dating, what kind of women will they attract? Those who can see beyond your crime and love them for who they are may have parents that discourage the relationship all because of you. They may learn to hide from their past and resort to lying to their partners, terrified that your crime will scare away their true loves. They may forever have a fear of abandonment, or they may avoid relationships altogether, believing that they do not deserve love. And much worse, they may fear that they'll turn into you. Each friendship, each romantic relationship will teeter on their ability to rise above the stigma, to rise above their trauma, to be confident in themselves, and to learn to love wholly and selflessly in spite of this experience. We will now pick up the pieces and show the boys that God's love and our love will one day heal their wounds, and that life can once again be beautiful. We will now sacrifice the lives we were living, the futures we had envisioned for ourselves, to be their parents and role models, to raise them in the way they deserve, to raise them in the way Becky would want. And we will do so together, my parents, Brett and I, because real love makes sacrifices. Judge Adrian, I request that Tim be sentenced to the furthest extent of the law, life in prison without parole. Our lives will be forever lived with an emptiness that can never be filled due to his premeditated and gruesome crime against humanity. Knowing he will face a lifetime of isolation and emptiness behind bars is only a small solace as we try to make sense of this inconceivable world without Becky.
Thank you, ma'am. All right, Mr. Jones, if that is it, then you may be heard in argument.
Thank you, Your Honor. May it please the court, counsel. Judge, I'll start with some basic housekeeping that we need to clear up. He's been convicted of 2 counts of murder and 1 count of home invasion. Those 3 counts should all merge into one sentence today. We won't be asking for separate sentences on each of those, and the order today would reflect that. Also, so we're all on the same page, the sentence for first-degree murder in the state of Illinois is 20 to 60 years. It would be served at 100%. So in other words, there is no day-for-day credit or 75% credit. Whatever sentence the court imposes, he must serve 100% of it. Additionally, because the jury specifically found by statute and by verdict that the defendant used a firearm in the course of committing the crime, there is an additional penalty of 25 years up to natural life. The 25 years is the minimum that the court can impose, but the court has the discretion to impose up to a natural life sentence in addition to the 20 to 60 years that is imposed for first-degree murder. That's the framework of the argument that I want to talk to the court about. Your Honor, in figuring out what I was going to say today, wasn't really sure. I thought about talking about Becky. I didn't really know her, but I've gotten to know her family very well for the past 6 months. I thought about talking about what kind of person she was, because for the last 6 months, we've been focused on the defendant and the defendant's rights and the things that are important to the trial. I know that it's frustrating to Becky's family. We've had to keep them in the dark about the facts of the case. We've had to not tell them things that they've wanted to know. They've had to ask us questions, and time again, the response to that question was, we can't tell you. I can't imagine how frustrating that's been to Becky's family, to be kept in the dark, to be told that we can't tell you things that we want to tell you because of our job, because we're trying to do the right thing by the defendant. We're trying to protect his rights when their sister, their daughter, their cousin was taken from them. That's not fair to them, but that's how the system is supposed to work. I thought about talking about Becky, but honestly, Your Honor, the words of her family are more powerful than anything I could ever say. And I came to the conclusion it doesn't really matter what I say. I'm not going to talk about Becky today. They've done that more powerfully than anything I can say. But what I do want to talk about, Your Honor, is the nature of this crime. We've seen, Your Honor, lots of different murders. We deal sometimes with the worst aspects of humanity. That's our job. That's your job as a judge. We've seen people come through this courtroom that have done violent, heinous, terrible crimes. But this wasn't a murder over a drug deal gone bad. This wasn't a bar fight. Hell, Your Honor, this wasn't a fight at all. This was an execution. This was a person who hunted and stalked his victim for days. For days. Who planned the murder, the execution, for days and for weeks. Who practiced the execution. Who had an opportunity after opportunity after opportunity to realize what he was about to do and turn away from it. Every time he rode that bike to the house, he could have decided, you know what, this isn't the right thing. And he didn't. Every night when he got home, he could have said, man, I am really glad I didn't go any further. But he didn't. No, every time he went a little bit further. He had so many opportunities to stop and choose to do the right thing, but he didn't. This was an execution that occurred while Becky was in her own home. The fear and the terror that she experienced in the last moments of her life as she held that door shut and as the defendant kicked it in, knocking the phone from her hand, and then she ran to the bathroom and she turned around and she heard a gunshot and she felt the pain of that bullet entering her body, paralyzing her from the waist down. She wasn't dead yet. And she fell to the ground. And then the defendant stood over her and he emptied the clip. He shot her 14 times, Your Honor. 14 times. The woman that at one point he had promised to love, he shot her 14 times. And he shot her at a time that at the very moment she was lying there slowly dying to death, slowly dying, bleeding to death, her 3 boys were asleep in his very own house. Your Honor, nothing I can say here today can replace the words of Becky's friends and family and loved ones. But what I encourage this court to think about is not just the effect on the family, but also the manner in which this crime occurred. There are many different ways a homicide, a murder, can be performed. In my 22 years as being a prosecutor, I have never seen a murder that was as planned, as meticulous, as thought out, as premeditated as this case. 14 times, Your Honor. She wasn't dead. She lay on that bathroom floor while her children were still asleep in the father's house. She lay on that bathroom floor, slowly bleeding to death. Your Honor, this defendant deserves a sentence of natural life.
Thank you, Mr. Jones. Ms. Schnock.
Your Honor, today's hearing and your consideration doesn't stop at the nature of the offense. I have not seen, nor do I believe will I ever see, a nice or decent murder. It is our position today, Your Honor, that the law is designed to punish those with life without parole only for the worst of the worst. As I said, there's no such thing as a good murderer. But if you look at the life Tim lived prior to February 23rd, I believe that Tim should be given credit where the law allows credit to be due. Tim obtained an education, a college education. I would be proud if my son obtained a college education like Tim did. He was fully and gainfully employed. I would be proud if my son were fully and gainfully employed. He was supporting his children financially, emotionally, and physically. I would be proud if my son turned into such a man. I would be proud if my son were a youth football coach and coached his sons like Tim did. I would be proud if my son turned into the man that would drop everything on a dime and dress up as the Grinch and show up at school for a holiday party. I would be proud to call my son a man like Tim was prior to February 23rd of 2023. Would I be proud if my son was sitting in this chair today? Absolutely not. But I would hope, for his sake, as I hope today, that credit would be given for the life that Tim lived prior to February 23rd of 23. He had done virtually everything that he was expected of him to his fullest abilities, whether that was in the classroom or on the football field or in the recycling facility. He lived his life as an upstanding member of society and lived his life the way that I believe we would all be proud for our children to live their lives. Being educated, going to church, raising your children in a faith-based lifestyle. He was doing all of those things prior to February 23rd. He has no prior criminal record, which is something that the court has to consider. He is not a habitual offender. He is not a career criminal that normally sits before the court in these sorts of circumstances. And the court cannot ignore the things that Tim has done in his life that were positive. The court needs to consider that, and I believe has to consider that. That does not make any of this right. That is not meant to be an excuse, but it is a fact. And it is a fact that should be considered by the court. And it is our position that a sentence in this matter of leniency, giving Tim hope that he could be released from prison one day, giving Tim hope that he could have freedom one day, giving Tim hope that one day he could be fully employed again, that he could support his children again, that he could go to church again, that he could be a productive member of society again. Today doesn't stop at the nature of the offense, and in any sentence that the court fashions, Your Honor, again, I would submit that life without parole should be reserved for the worst of the worst, and Tim is not the worst of the worst. I think most of us in the community have seen the worst of the worst in the past month or so, and that certainly isn't Tim. He's lived his life fully. He's lived his life as expected up until February 23rd. And I would respectfully request on Tim's behalf and on his family's behalf that leniency be given and that he be given credit, and the court should take into consideration the way Tim lived his life and the way that he conducted himself prior to February 23rd and prior to Becky's murder. Thank you.
Thank you, Ms. Schnock. Mr. Jones.
Thank you, Your Honor. Your Honor, I have no dispute with the fact that the defendant was college educated and fully employed. What I do disagree with counsel on is that he should be given credit for that. So many times in these cases, we see defendants who aren't college educated, who aren't fully employed, and it still doesn't prevent them from doing the right thing. Mr. Bliefnick had every opportunity to do the right thing. He had every advantage in life that would prevent him from feeling the need to commit this crime, and yet he still made this choice. And it wasn't a split-second decision, Your Honor. It just went too far. This was a premeditated stalking and execution case. That's what he did. The defense asked for a sentence of leniency, hope, and mercy. Your Honor, I ask that this court today show this defendant the same leniency that he showed Becky Bliefnick on February 23rd when he fired 14 bullets into her body. I ask that this court show him the same hope he showed his wife when he stood over her and fired that gun again and again and again. And on August 11, 2023, I ask this court to show him the same mercy he showed Becky Bliefnick when he left her alone on that cold bathroom floor, paralyzed from the waist down, unable to breathe because a bullet had pierced her lung. Show him the same mercy he showed her on February 23rd when he left her to die completely and utterly alone.
Thank you, Mr. Jones. Mr. Bliefnick, before I sentence you, you have a right to make a statement to me. Is there anything you'd like to say?
No, Your Honor.
The court has considered the pre-sentence investigation report, has considered the addendums thereto, has considered the victim impact statements that were given in court, has considered each and every factor in aggravation and mitigation, and the arguments of counsel that were made here today. Mr. Bliefnick, you researched this murder, you planned this murder, you practiced this murder, you broke into her house, and you shot her 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. I don't know how long it took you to do that. Some of those shots were fired while she was lying on the ground. And you did all of that while your children were upstairs at your house, lying snug in their beds. The court believes that the appropriate sentence for each of the 2 counts of first-degree murder would be natural life in prison. Court believes that the 3rd count of home invasion, appropriate sentence is life in prison. Those 3 sentences will merge together into one life sentence. And then, Mr. Bliefnick, I need to give you your appeal rights. You have the right to appeal the finding of guilty and the sentence that has been imposed. The right to appeal the judgment of conviction, excluding the sentence imposed, will be preserved only if a notice of appeal is filed in the trial court within 30 days from today's date. If you desire to challenge the sentence or any aspect of the sentencing hearing, you must file prior to an appeal and within 30 days of today a written motion asking the trial court to reconsider the sentence imposed or to consider any challenges to the sentencing hearing, setting forth in the motion all issues or claims of error regarding the sentence imposed or the sentencing hearing. If you are indigent, a copy of the transcript of the proceedings of the trial and sentencing hearing will be provided, and an attorney will be appointed to assist you in the appeal or the motion to reconsider the sentence. You also have the right to ask the clerk of the court to prepare and file a notice of that appeal. You must set forth in your motions all issues or claims of error regarding the sentence imposed or the sentencing hearing. Any issue or claim of error regarding the sentence imposed or the sentencing hearing not raised in the written motion shall be deemed waived. An appeal must be filed within 30 days of sentencing, or if a motion to reconsider the sentence has been filed and denied within 30 days of the denial of the motion, or you will lose your right to appeal. If it is your desire to file a motion to reconsider the sentence, do not file a notice of appeal until after the motion is decided. Under Supreme Court Rule 606, if a timely motion to reconsider is filed, any notice of appeal filed before or after the motion will be stricken. Mr. Bliefnick, do you understand your appeal rights?
Yes, Your Honor.
Your Honor, I would ask that Mr. Bliefnick be declared indigent and that the matter be referred to the appellate defender's
The
office.
court will do that, and the court will sign an order appointing the appellate defender to represent the defendant.
Thank you.